This is what I wanted to chat about. And, we have consumers on here, so you may be facing this, or you may have family members or friends facing this. And we have some guys that run credit repair companies. And so your customers may be facing this. And so I thought this would be helpful to go over some key ideas that are really, you need to know if you're being sued by one of these debt collectors, these debt buyers. And there's a whole host of these companies. There's Jefferson Capital, there's Calvary, there's Unifund. But the three I've listed, LVNV, Midland, which is Midland Credit, Midland Funding, and Portfolio, at least in Alabama, where I practice, and in other states that I'm familiar with, these are the majority of the debt buyer lawsuits. And so I'm going to probably just refer to these guys as we go through here. So I've really done this in the form of questions because I just find that's the best way to learn. And since we do have some people on here, you guys are welcome to respond in the chat, and I'll give you some thoughts also. But what's the biggest danger facing a consumer who's been sued by a debt collector if they just do nothing? What is either the danger, or maybe there's multiple dangers, but what's the problem with doing nothing? Because I tell you, there's a lot of consumers that say, well, I had that old Synchrony Bank credit card, or I had that old Capital One credit card. I'm being sued now by LVNV, Midland, Portfolio, Calvary, somebody like that. I'm just not going to do anything. What's the danger to the consumer by just doing nothing? Just saying, okay, I've been sued, I've been served. I'm just not going to take any action at all. What would you say is the biggest danger facing the consumer? And just put that in the chat, if you will, because we need to know what's the danger in order to know, well, is it important to do something? In other words, if there's really no danger, no downside to doing nothing, then why would I take some action? And let's see. Yeah, Warren says you lose. Jeff says judgment against you. That's absolutely right. So typically this is called a default judgment. That's right. Brian says default judgment plus cost to collect. So a default just means we don't show up. So Super Bowl happens, one team doesn't show up, they lose. They lose by default. Okay. So same thing in court. If we don't show up and file an answer, or whatever our state tells us to file, if we don't file that response in time, then the debt buyer, the debt collector, can get a judgment against us. And then when they have a judgment, what can they do to us? So Midland sues me, I don't respond, they get a judgment against me, and I say to you, so what? They can't do anything to me. What's the problem with that type of thinking? Yeah, so Fleur says garnish account. That's right, your bank account. Brian, garnish wages. Cedric, garnish wages. And all this depends on your state, okay? Some states do not allow for wage garnishment. I want to say maybe Texas is that way. I'm not sure though. I think all states allow bank accounts to be garnished. Now, certain funds are what are called exempt, so Social Security type funds. But, if we're not talking about exempt funds, they can wipe out our bank account. And then, your mortgage check hits and your auto draft on your car loan and all this other stuff, and there's no money there. And people say, well, that's not fair. Well, that's the problem with getting a judgment, is they can do this bad stuff to us. Yeah, Warren says, take your money. Jeff says, seize your car, your art collection, whatever you have, sell it. That's right. So they can do wage garnishment. They can do bank account garnishment. Some places will call this a levy. Okay. It's what the IRS typically calls it when they take your money. They call it a levy. But most states call it a garnishment. And then they can seize property, real property, personal property. Again, it depends on the state. In Alabama, we call that a sheriff's sale, where it's sort of like a foreclosure, but the sheriff sort of holds an auction, for your car or your house or whatever it is. And so very, very bad consequences. And I know Warren says, not my art. So Warren and Cedric and maybe some others are in Stephen Palmieri's group. And I think there was a comment put up or question put up, maybe yesterday or today. I just saw it today. And somebody was saying they had a customer that they were doing credit repair for. And all of a sudden, this judgment appears, like $17,000 judgment. Now they can't, I think they were refining their house. And yeah, if you get a judgment, it can be a lien on your property. Okay. So even if they don't seize or take your property, there's a lien there. So when you go to sell it, go to refinance, you got a big problem because this thing is sitting there and has to be paid. So all sorts of downsides. We just don't want a default judgment. So we want to respond. But here's the next thing. If you owe the original creditor, so say Warren owes Synchrony Bank, does that mean Warren owes the debt buyer, Midland Portfolio? So are those two things equal? I owe Synchrony Bank, so therefore I owe Midland Portfolio, Calvary, LVNV, whoever it is. And not surprisingly, Warren says no. He says they're not taking my art and I don't owe them. Okay. And same thing here with I don't believe so. So yeah, that's right, because there's a difference here between owing and owning. And let me just write that on here. Let's see here. All right. So if we look at this, I may owe somebody money, but the question is, whoever's suing me, do they own the debt? Okay. So I'll pick on Warren a little bit longer. So let's say Warren has a mortgage to Bank of America for $200,000 on his house. And he freely admits, hey, I have, $1,500 a month payments that I owe to the bank. And so I sue Warren and say, I want those mortgage payments paid to me. And the judge says, well, now, Warren, do you owe money on your house? He goes, well, yes, Your Honor, I do. And then I say, well, see, it's over. You owe me the money. I think Warren would say, and the judge would say, yeah, but who in the world are you, John? You're not Bank of America. And then I go, oh, well, I bought the note from Bank of America. Just trust me, I did. So you can pay me the money. Well, I think Warren would say, yeah, you got to prove that. I may owe money, but as Warren said in the comment, not to John. That's right. You don't owe me the money. So if Capital One sues me, and I've mentioned this before in other videos, but let me just take you back to some of the very first cases that we handled against these debt buyers. And I had never heard of debt buyers. I had never been in small claims court. And this is about 2005, 6, something like that. And I had a client sued by, let's just say it's LVNV. And so I go in there and, the lawyer comes to me, collection lawyer says, well, John, how much do you want to pay? And I'm like, we're not paying anything. He's like, well, are you saying this is identity theft? I said, no, we don't owe you any money. He's like, well, John, we bought the debt. I'm like, well, let's see. Let's go to trial. So the judge says, did y'all work it out? And the collection lawyer's like, no, this guy says he's not going to pay us any money. And the judge looks at me and says, John, did your client owe, Capital One? I go, yeah. Well, then what's the problem, John? I go, Capital One didn't sue me. This is LVNV. He's like, yeah, but they bought it. I go, well, that's what they have to prove. They claim to have bought it. I could claim to be the president of the United States of America. It doesn't make it true. Okay. And then the judge got it. Like, okay, yeah, you got to have proof of this. And, the collection lawyer was not happy. I mean, nobody had done this to him before. And so, we really started pushing this concept. I think I wrote a blog article on this like in 2007. It's like the only article I ever wrote that sort of went viral, some other publication picked it up. And it's just this idea of knowing the difference between you owing a debt and a debt buyer owning the debt. See, just because Warren owes money doesn't mean he owes it to me unless I own that debt or I own the right to collect the money. So It's a very, very important concept to understand because so many people will say, well, look, I owe Synchrony Bank or I owe Capital One or whoever, so there's no hope for me. And that's just not true. So here's the last thing. What are your 5 options? And I was sitting down with somebody, and this is probably, I don't know, 2008 or so. And they were saying, well, look, I got sued. It's a pretty big lawsuit, maybe $15,000. And he's like, what can I do? And I went through these options, and I had never really set them in this way. And so I don't know if you ever do this. Maybe it's just me. Maybe I'm slightly insane or something. But like I told this guy his options, and I thought, wait a minute, that's actually pretty good. I need to write this down. So I remember, and he was a good guy. We had a good relationship. I was like, hang on one second, I got to write something down. So I wrote down these 5 options, and ever since I've been teaching this because I think it's a very helpful way to think about, okay, I don't want a default judgment. Okay, I understand the difference between me owing the original creditor and the debt buyer owning the debt. So what can I do now? Okay, so here are the 5 options very quickly. Number 1, file bankruptcy. I'm not a fan of that. Maybe every 200 people that come to me that have been sued, do I say, hey, you need to go see a bankruptcy lawyer? Because usually there are better options, but it's something to consider. The upside is if you can do a Chapter 7 bankruptcy, you wipe out all this debt, okay? The downside is you have a bankruptcy. And, an example I've often used is it may be too extreme. So if I say to Cedric, hey, my little finger hurts, and he says, I can fix that, and he pulls out an axe and he chops off my arm, well, my finger doesn't hurt anymore, but Cedric, that was a little bit excessive. Okay. That was not necessary to do that. And that's how I feel about bankruptcy. For most people, I think it's too extreme of an option. Okay. So what are the other options? Well, you can do bankruptcy. You can fight it on your own. So you don't have to hire a lawyer. You don't have to pay a lawyer. The positive is you don't have to pay a lawyer. The downside is you don't have a lawyer representing you. So you have to learn this on your own. And we often talk about when really anything we're dealing with, we either spend time or we spend money. You want to fix your own credit report, then you're spending time. You want somebody else to fix your credit report, then you're spending money. Those are both legitimate options, but sometimes people say, well, I don't want to spend any time doing this and I don't want to spend any money. Well, I haven't figured that one out. Okay. So you're spending a lot of time to do this on your own. And it certainly helps if you can talk to a lawyer in your state and say, hey, is this realistic to do this on my own? So I tell people all the time in Alabama, if you're sued in small claims court or what we call district court, if you're willing to put the work in, it's an option. It's a valid option. Now, if you're sued in the higher court, you can technically do it on your own, but incredibly unlikely you'll be successful. So, this is a legitimate option. You just need to know details about for you and your particular court, is this an option? So third option is you can settle it on your own. So you don't pay a lawyer any money, but you're paying the debt buyer money. And you need to know, are they going to get rid of the credit reporting? And what about taxes? So if I owe Brian $10,000 and he accepts $7,000 from me, then he really needs to tell the IRS I have $3,000 in income for forgiven debt. And you have to assume these debt buyers will do that. So you just want to understand that before you settle. So bankruptcy, fight it on your own, settle it on your own, hire a lawyer to fight it. So you're paying a lawyer money, need to know exactly how much that is. And then what's the game plan? What's the strategy for winning? And what happens if we lose? What is the lawyer going to do at that point? And then the fifth one is to hire a lawyer to settle the case. So again, you're paying a lawyer money. And if you're paying the debt buyer money, you sort of have to add that up. Is that a better deal than you doing it on your own? Now, I'll just tell you, at my firm, when people are sued by a debt buyer, we do not pay the debt buyer any money. We'll settle with them, but it's just what we call a walkaway settlement. So we don't sue them. They drop the lawsuit against us. And this is what's called disputed debt, which helps as far as taxes. And the fact that we didn't pay them a single penny. It's kind of hard for them to say they forgave us debt when we didn't pay them any money. So that's the way that I do it. But in your state, just go through these options. Say, okay, is bankruptcy, should I fight it on my own, settle it on my own, hire a lawyer to fight it, or hire a lawyer to settle it? And that leaves a few other things that we can talk about, in a future webinar. But, how do you file an answer in your state? What are the deadlines? Well, that you have to research, or you look at the summons, which is a document that sits on top of the lawsuit. It says, here's your deadline. Here's where you return the answer. Okay. Do you do it electronically? Do you file it in person? What do you do? And then how do trials work in your state? And what I've always recommended, and COVID kind of, made this difficult, but it still is possible. You need to know, how does your judge handle cases? Okay. So not just in general, how are cases handled in Georgia or Minnesota or Wisconsin or Alabama, but in your county, how are cases handled? And even within your courthouse, how does Judge Smith handle them? Doesn't really matter what Judge Jones does. How about Judge Smith? You need to know, how does she handle her cases? Because it may be totally different than the judge next door. So the way you find that out is you go watch some trials before your trial date. Go watch. Is this judge formal, informal? How do they handle evidence? How do they handle arguments? Do they want everything really fast? Do they take a long time? You really want to know answers to those types of questions. And if you'll go watch your judge, then on the day of your trial, you'll know, here's where I park, here's how I get through security, here's how I get to my particular courtroom. I can't tell you the number of people that have called my firm and said, hey, I lost, but I showed up. Like, what happened? I don't know. I sat in a dark courtroom for 2 hours. Okay. And I was in the wrong courtroom, or kind of like me today with doing this webinar an hour ago. I just showed up at the wrong time. Okay. And so you want to know that you know exactly where to go, that you'll recognize, okay, yeah, I am in Judge Smith's courtroom. Because, here's the problem. Some courthouses have judges with the same last name. And we had one court, actually, they were a married couple, and so you'd say, well, Judge so-and-so, well, which one? The husband or the wife? And so you just want to know what your judge looks like. And it just helps to sort of bring down the nerves if you've sat in there before, you've observed what's happened. Now, if it's happening by Zoom, you may ask the judge, can I appear and just watch on Zoom? Most courts recognize that they're open to the public, even on Zoom. And so if you ask, you may be able to do that. What about mistakes people make? I have a video on this, like 35 minutes, but I'm happy to also do a webinar on it. Just sort of simple mistakes that we see people making when they testify. And then what about if you win your case? What happens? Well, here's the short answer. This needs to come off your credit report if you win. And if it doesn't, and particularly if you dispute it, those can be incredibly valuable lawsuits. And then there may be other, questions or thoughts that you have. So we still have some time. If anybody has questions about this, or it can be anything else consumer related, I'm happy to answer questions. And let me see, you definitely can put a chat up. I'm trying to think. I believe there's a way that I can add people to this if you want to appear by video. I'm now struggling to see exactly how I do that. But anyway, so if you have a question, let me know, and I'm happy to go over that. And let me stop the sharing of the screen here. So yeah, so I'll check the chat here. Let me get back to that. Let's see if we have any questions. Let's see. So it looks like maybe I had a problem with connection, or Flurry did. Somebody it said lost you, sir. Okay, so hopefully it's been recording. I haven't gotten a message, so you'll get a replay link, and hopefully that will help. But sorry for any connection problem. So Warren says, what are some common or easy to identify violations on the credit report? So it's a great question, Warren. I guess I'd break it into a couple things. One would be for debt collectors. So, if you see that you have a debt collector, and I try to use a little bit of judgment in this. I mean, if it's $10,000, I may not send them a letter because that might trigger a lawsuit. But if it's $1,000, a couple $1,000, or definitely smaller, you can send a cease communications letter. So we call that a refuse to pay letter. And you can send a validation letter. And Warren, I'm not sure if you were on the webinar we did. It's probably like an hour and a half on different types of dispute letters to send directly to collectors. If you weren't on that, just let me know and I'll get you the link to that. Just email me and I'll send you the replay link to that. But that's one way to kind of start with the collectors, send some letters out, see what they're going to do because they may violate. But if we're just talking about the credit report itself, to me, the easiest thing is to find the missing data. Okay, so when you have that sort of trended data, typically 24 months, where for each month it's going to show, the balance, the scheduled payment, the actual payment, the rating, all that sort of stuff. And even if it doesn't have that, if it just has the rating, so current or 30 days, 60 days, if you find the just missing data there, to me, that's just the easiest thing. And, you just do a letter. And obviously I know, Warren, you know how to do dispute letters, but I like to be very specific. So I don't say you're missing data on the payment history. I mean, I guess that's okay. I just don't feel as comfortable with that in suing. So I like to say, hey, in the month of June 2018, you have no data listed. Either fill in that data accurately or get the whole account off my report. Well, then they have a choice. They either fill it in and then you can see if it's accurate, or they can delete the account. And so I only dispute accounts that I'm comfortable being deleted. That's great. Or they say, no, we're not going to fix anything. And then I sue them. And then they delete it and they pay money. So to me, just looking for that missing data. And then, maybe a step above that is the contradictory data. And we've talked about this before. It says I'm current this month, and then next month it says I'm 60 days late. How's that possible? How did I go from being current to 60 days late? I'm trying to remember if I used this example before. This was a Barclays account, and it said that it was sold, I want to say like December 2000. No, it was sold January 2019. Okay. Well, then there's a portfolio recovery and it says, hey, we bought it from Barclays. It's the exact same number. And it says that they bought it, when was this sort of open for collection? In December 2018. So I'm looking at that going, how did Portfolio buy it a month before Barclays sold it? That's a contradiction. And so, I find these just by putting stuff on a spreadsheet and sort of looking at it. Obviously, there are other ways to do it. Stephen has his software, you can use that. But this is one reason why I absolutely love the actual credit reports instead of using like Smart Credit or Identity IQ, because unless they've changed, they don't have that full trended data. And it's just so many more places that you can find where they're not reporting data correctly or even at all. And then it gives you a basis to challenge it. So hopefully that's helpful to you. See, Brian says, love to hear you present some time on valuing FDCPA, FCRA claims. I often have clients who have slam dunk on liability, but it's difficult to figure out what the full value is. So that's a great question, Brian. And Brian, let me know if you're a lawyer or if you're running a credit repair group organization. I just had this conversation actually with a lawyer who he does this, and he runs a credit repair group, Maurice Scott. He's in Alabama, great guy. And we were talking about this. Most of my cases, I'm going to say the vast majority of my cases are great on liability. And most people would look at my cases and say, but they don't have much in the way of damages. There's no credit turned down. You had 12 other negative accounts and you're suing over, this error on a 13th account. And, the credit bureaus always come to us and say, John, your client, has a bad credit report. And I mean, surely we can't have caused any harm. And I'm like, yeah, you did. You made it worse. Okay. It would have been less damage if they had had a perfect credit report, because they could have absorbed your wrongful conduct. But if you're already been kicked to the curb, somebody else kicking you there, it's just worse because they keep you down. And so we primarily use emotional distress damages and punitive damages to get what I think is pretty high value. I mean, I have cases I talk to lawyers too, and I'll describe what our case is, and they'll say, "Oh yeah, you probably got like $3,000 for that." And I'm like, "No, we got many, many multiples of that." And so anyway, the you have to know what your law is in your state, in your circuit, on emotional distress damages. There are some circuits that are more difficult. In the 11th Circuit where I practice, which is Alabama, Georgia, Florida, there are no special restrictions or more difficult proof requirements. Now, sometimes judges think that there are, and we had a judge who wrote an opinion and said there was this higher standard, and we asked her to reconsider that. And to her credit, she wrote this, 15-page opinion saying, you know what, I got it wrong. There is no heightened standard for emotional distress damages. It's just normal proof. And so that may be the plaintiff themselves talking about, hey, this is why it was so distressing, so upsetting to me. It may be family members talking about it. But you have to know what your law is, and then to understand, well, how do I persuade a jury about this emotional distress? And I think a lot of that is tied in with, and it may actually be the last video I did on YouTube, a little behind on that, but just talking about how insulting it is that these credit bureaus, they have this false information, incomplete information on us. We do this detailed dispute letter to them, point out every single thing, and we get back some nonsensical form letter. Okay. Isn't that insulting? Isn't that just treating me with contempt? That they go, hey, you put all these hours into you know what? We're just going to give you this form letter. You disputed 8 items. We're only going to address 3 of them. We're not even going to answer any of your questions. To me, that's insulting. And I think, our clients are upset by this because it's a sense of powerlessness. Here's this credit bureau. They didn't ask me if they can keep a credit report on me. They just do it. Okay, that's fine. But when they get it wrong and I dispute it, they should fix it. And when they don't fix it, it's like, wait a minute, you have all this power over me and you won't even do the right thing. And so that's why people get so frustrated, so upset, and frankly, why juries get upset at these companies. So I think that they do have value. And Brian, I'm happy to, let's see, I see you say I'm attorney, but I don't practice in this area full time, settling for too little. Brian, just email me and let's jump on a phone call and go over this, and we can get into some more specifics on that. Let's see. Flory says, just learned my 13-year-old stepson has a medical collection from 2018. That is very odd. So are you saying that this is somebody's trying to collect this against your stepson, or they're saying a bill related to your stepson is your responsibility? And so maybe just give me a little bit more feedback on that. And then Jeff says, what if we get sued by the 4th debt collector where the previous 3 were disputed and removed from the bureaus? So it's a great question, Jeff. So being removed from the credit reports doesn't affect whether we owe the debt or not. We can still be liable on the debt. They just happen to not credit report. So the fact that it's removed doesn't necessarily mean that this fourth collector is in the wrong suing us. But certainly, if those other companies claim to own the debt, so Portfolio never collects for somebody else, they always claim to own it. Same thing with Midland, same thing with LVNV. So if, let's say, LVNV was reporting in, then Portfolio was reporting in, now Midland's suing you on the same debt, there's just a whole bunch of steps there from original creditor to, whatever I said, LVNV, Portfolio, Midland, every step of the way, they have to show ownership. And when we're talking about LVNV, keep in mind it never goes directly from the original creditor to LVNV. It goes from the original creditor. Once it starts to get near LVNV, it goes to like Sherman Acquisition 4 and Sherman Acquisition 1 and Resurgent. There's all these different companies that it travels through. Well, my view is every one of those companies, they have to come with the actual contract, the purchase agreement, and a witness to prove this. And so the more steps there are, the more complicated it is. Look, I don't do criminal law, but I know like with DUIs, there's this thing, sort of chain of custody of the evidence. And if it's changed hands 27 times, it's just more complicated to prove that it wasn't altered or compromised in some way. Let's see. Laura says, just served by Capital One, no arbitration agreement. Yeah, typically Capital One, they used to always have ARB agreements, but they don't anymore. Maybe they'll change it. I'm not sure. So I'm seeking a settlement. Question, what's the lowest percentage you've seen them settle for as a lump sum? Wonder if it's risky to wait until last minute to file an answer. Would prefer not to pay the filing fee if I can complete negotiation, sign an agreement, 28 days. So let's take the first question, lowest percentage. They certainly will take lower than this before a lawsuit, but once they're suing and there's lawyers involved, typically the lowest we see them go is about 50 cents on the dollar. So if you're sued for, $8,000, then probably $4,000. Now, typically when they're not dealing with a lawyer, they make that percentage be higher. So it's something that it's probably worth it for you to talk to a lawyer in your state and just say, hey, how much to settle this for? First of all, what will it take to settle it? And how much would you charge me? And then kind of compare that with what you think that they would do. So you might even ask them, ask Capital One's lawyers, hey, what would you take as a settlement? And they give you a number, compare that with what a lawyer says, hey, here's what I always do. And, it might be in your best interest to do it on your own or to get a lawyer. Now, you mentioned a filing fee. So I can tell you in Alabama, for example, there's no filing fee for an answer. But I know in California there is. I think it's maybe a couple $100, which is just sort of shocking to me. So I definitely understand not wanting to spend that money if you don't need to. You should be able to settle it, within 28 days. And it's really just going to depend most likely on how quickly can you pay, because you would want to settle it and pay them and make sure that money clears. So take them like a cashier's check, money order, ask them how they want it so that they can dismiss the case with prejudice before your deadline to answer would come up. But Laura, I would definitely get with a lawyer in your state and just, see what your options are. Does it make sense to hire a lawyer? And I would get with somebody who does this. So not somebody that all they do is bankruptcy, but somebody that actually deals with people being sued. And, I can tell you, we tell people, hey, look, here's what you can do on your own. Here's what you can do if you hire us, make your decision what you want to do. And I would certainly hope that where you are, that they would do the same for you. Cedric says, I'm confused about the open date for medical on credit reports. The medical service date is when I went to the hospital. Yes. So Cedric, is this with a collector or directly with the provider? Because because with the collector, and I know you know this, the collector is going to be when they received it. If it's, a hospital, for example, and I don't normally see them reporting directly. I guess they could. Um, I guess the open date should be I guess would be the service date when you win. I've actually never seen that. So that's a good question. Um, okay, Cedric, you say yes, the collector. Yeah, so the collector should be when the collector received it. That would be the open date. So I go to the hospital on January 1st of this year, and XYZ collector pops up on my credit report and they put an open date of July of this year. Well, then that's when they received it. If they put, January, then I think that would be inaccurate unless they like received it immediately. Okay. So that's what I would look for there. If you have any specifics, just let me know, and happy to chat about that either here or, we can chat offline. See, Warren says, thanks. You're very welcome. Um, let's see. Flore says, Bill relays with collection agency Optimum Outsource, however, not received any correspondence regarding such debt. So is that just popping up on your credit report, or are you getting calls from that Optimum Outsource? I'm not familiar with them. Let's see. Warren says, what's your email? Let me type that. And let's see, I've got a few more minutes here if you guys have any other questions. And Flore, if you tell me how you found out about this bill, and is it in your name or your stepson's name? I mean, it shouldn't be in your name. Oh, okay. Let's see. Actually, I contacted the hospital regarding another issue, learned of this. Okay. So you got a couple options. You could contact the collector. Hospital should be able to give you their address or look them up, and you could send them a letter saying, hey guys, I don't know who you are, I dispute any debt, send me proof, and see what they do. Or if you think you owe it, so you talk to the hospital and they say, well, it's for this procedure, and you check back through your health insurance and you're like, oh yeah, I do owe that. Then what I would do is ask the hospital if you could pay them, and they recall the debt from this Optimum Outsource. Because if they recall the debt, then it definitely, wouldn't be on your credit report. Or if it is, you can certainly dispute that or maybe even sue the collector. But you want to get that pulled back from the collector so that you can pay the hospital directly and not have this be on your credit report. That would be my suggestion. Now, if you think you don't owe it or it's the wrong amount, then I would look at either addressing that with the hospital or disputing that with the debt collector and see what kind of response you get. Let's see. Say it's not on my credit report, at least not that I'm aware of. Yeah, just check your reports every week, annualcreditreport.com. And let me just type this in here. And, just once a week, check your actual credit report, see if it's on there, see if they're pulling your report. Um, you know, obviously see if they're sending you letters, if they're calling you. And, but I would probably start with the hospital first and then, kind of see, do you think you owe it? I know one time I had a kid that had an MRI and I paid for it. And then I got a collector that sent a letter and it's for an MRI. And I'm like, I already paid this. And so I called the hospital and they said, well, remember, we actually did 2 MRIs the same day. I'm like, oh, yeah, I forgot about that. So then I realized I owed the debt. But, there's a lot of times with medical billing that there are all sorts of errors involved. And so, if you can talk to the hospital, maybe you can realize you don't owe it and convince them you don't owe it and they'll pull that account. Or if you do owe it, say, look, I'll pay you guys, but I don't want this to appear on my credit report. Can you guys pull it back from this Optimum outsource? And, the worst thing to say is no, but they may say yes. And that would, prevent you from having to deal with that collector. And, well, listen, guys, thanks for showing up, and appreciate you guys showing up on time, unlike me, an hour and a half ago. But hope this was helpful to you. And if you have any requests or suggestions for weekly topics, let me know. And if not, then we'll probably start with those new FDCPA rules because I think that will be very, very important. And it's just going to change really debt collection in a massive way. And I think we will see lots and lots of violations. So, okay, guys, y'all take care. And Brian, definitely get with me. You can just shoot me an email, Brian, or respond back to any of the emails from this Demio webinar software. And I'll be glad to jump on a call with you. Okay, guys, y'all have a good one. I'll see you next week. Bye-bye.